My name is Michael Busby. I am a Texas family law and divorce attorney who practices family law in the family law courts of Harris and Fort Bend County, Texas. In this presentation, we will talk about jurisdiction to modify a foreign child custody determination as permitted under the Texas Family Code, also what we refer to as the domestication of a foreign order for the purposes of modifying that order for a child who is under the age of majority. So the family code provision that we are going to discuss here is 152.201 and 152.203, that a Texas court has the ability to modify a court order of another state if Texas, at the time of filing the modification, can make the initial determination as required under the Uniform Child Custody Jurisdiction and Enforcement Act. Therefore, Texas would be the home state of the child for the preceding 6 months. And the court of the other state determines it no longer has exclusive continuing jurisdiction under section 152.202, which is exclusive continuing jurisdiction. The court of the other state determines that a court of this state would be a more convenient forum, or a Texas court or a court of the other state has determined that the child's parents, and any person acting as a parent do not presently reside in the original incepting state that initiated the first order. Under section 152.203, that unless no one resides in the other state, the court of the other state must determine it no longer has continuing exclusive jurisdiction, or that it should decline jurisdiction. A Texas court may only make this decision to assume jurisdiction if it finds no one presently resides in the other state. Even then, the Texas court must still determine it has jurisdiction to make an initial determination under section 152.201. So the application of this statute has to do with you have the primary parent who resides in Texas, and that person wants to domesticate a foreign order, let's say from California, and no one resides in California. The father, the mother, a person acting as a parent. And so in that situation, Texas law provides that a original certified copy of the final order be filed with the clerk with a letter that asks that the clerk domesticate that particular order. And then a case number is issued, a certified mail is sent to the address that is the address which is given for the parent or the person acting as a parent who is subject to the order that you're seeking to modify. And that person gives an opportunity to contest jurisdiction. And as they are given an opportunity to contest jurisdiction and there's no contest, you wait 30 days, then you turn around and you file your petition to modify, and you have a Texas case number that's issued, and then you can seek the relief that you may want to seek, whether it's rights and duties or it is on possession and access. And so if you have someone who still resides in the foreign state, and in that foreign state a parent or a parent acting as a parent still resides there, then the Texas law says you must go to the court with continuing exclusive jurisdiction and seek a release that Texas is a more convenient forum, or that the foreign state no longer has a significant connection with the child because the child's relationships have all been pretty much in the foreign state diminished and or lost because of time. And so a state of this court that made a child custody determination but no longer has exclusive continuing jurisdiction under section 155-202 may modify that determination only if it has jurisdiction to make an initial determination. This is the 6-month period. So for Texas to assume jurisdiction, Texas has to find that for 6 months prior to the filing of the domestication that the child had resided in Texas. And so that is the process and procedure for the jurisdiction for Texas to modify a foreign child custody determination or final order.